Please join me in giving Professor Stephen Ware a warm Pachyderm Club welcome.
Thank all of you for being here. As John mentioned, this is a topic I've been working on for 16 years here in Kansas, but really longer in other places. And so just anybody willing to talk with me about it is special for me. It's something I really care about, and I look forward to hearing your questions and comments. And John was nice enough to give me a clicker, so let's see if this, before I click away, if I say anything that you want to follow up on, I've put my phone and email here, so please don't hesitate to follow up after today if there's anything to discuss further. That would be great. As you can see on the screen, I hope, I guess that's the other thing I should ask the folks. Can they see the screen? Thanks. My title topic, Kansas Supreme Court Selection and Retention in National Perspective. And the national perspective is the other 49 states, how they select their Supreme Courts. So I'll first try to tell you a little bit to build up my credibility, that I'm somebody you want to think is a reliable source on this topic, which is publications I've had on this topic of Kansas Supreme Court selection. The first couple are what John rightly called law review articles, so many pages of all the detail with all the footnotes that scholars and lawyers might read if they're interested in the issue, and then several newspaper opinion pieces around the state. Wichita, you see here, Lawrence, Kansas City Star. So several pieces designed to bring this issue to a wider audience than just lawyers or scholars who have a specialized interest in it. And I have also testified several times before our state's legislature about Kansas Supreme Court selection. So I mentioned selection and retention as the topic, and that's the place I'd like to start, is the distinction between what's the process that first puts a judge on a court, distinguish that from the process that decides whether the judge stays on the court. That would be judicial retention. So that's the distinction I start with here, and what I'll try to do is a very quick history. So this is over 200 years in the United States in one PowerPoint slide. Very quick history, which is we start with the framers of the U.S. Constitution, who had federal judges selected by the other two branches of government. The president nominates, and then the Senate votes to confirm. That's the model of judicial selection from the U.S. Constitution. We've had it for a long time. And some states also follow this basic model where the high court of that state, those judges are selected where the governor nominates, and then the legislature or some other elected body votes to confirm or not. And so if you look at the states that were in the original 13, there still, some of them have that model. But as the nation moved west into the Appalachian Mountains and what we now call the Central Time Zone, was around the same time, you might remember from your history class, Andrew Jackson, President Jackson, populism, right? Take power away from the elite and spread it among the common folks. Basic idea of Jacksonian populism. What does that mean for selecting judges? It means elections. Having ordinary citizens vote for judge the same way they would vote for other offices in the other branches of government. So that was the big wave, the big trend in the mid to late 1800s. All the states that became states in that era initially had elected Supreme Courts. And by elected, I mean what I have to call contestable elections. We might think of them as normal elections, but in this topic of judicial selection, I have to call them contestable elections. They're normal because you can have two or more candidates on the ballot, so the voters can choose among two or more candidates. That's what I think of as a normal election, as opposed to what we're going to see in a minute is an election that only has one candidate on the ballot, and we call that a retention election, where a judge is running to keep the position on the court, and the voters just get to vote yes or no, do we want to keep this judge on the court. That's a retention election with just that one candidate versus here in the Jacksonian democracy approach, that's contestable elections. Multiple candidates can be on the ballot. And I mentioned retention elections. That's a characteristic of the third big common method of selecting judges around the country, which was invented in the progressive era of the early 1900s. Again, if you think back to your US history, after the Jacksonian populism of the 1800s, as our society industrialized and grew and became more complex, a common view was that, hey, letting the common citizens vote, things are getting too complicated for that. We need experts. We need administrative agencies to bring expertise into government. So the growth of I think John referred to the administrative state earlier, starts in that progressive era. And where does that idea take us with selecting judges? It takes us to the experts should play an extra role in selecting judges. And who are the experts there? The argument is lawyers are the experts. So the idea is that lawyers and other people will focus on the professional merits of somebody who wants to be a judge as opposed to their political views. Reduce the influence of politics in judicial selection and have it be a more merit-based system is the idea, or the sales pitch for that system. And its advocates call it merit selection. I think a more neutral name for it is the Missouri Plan, which is another common name for it because Missouri was the first state to adopt it for their Supreme Court. And several other states in this part of the country adopted it for their Supreme Courts, including Kansas in the 50s. So to talk a little bit more detail about Kansas, if there's a vacancy on the Kansas Supreme Court, then people who want that job apply to the Kansas Supreme Court Nominating Commission. The Nominating Commission is at the center of this process because it takes the applicants and winnows them down to three finalists. And then the governor must pick one of those three people who then becomes a justice on the Kansas Supreme Court. Meaning the commission narrows down the pool to three, the governor must pick one of those three, there's no Senate confirmation or anybody else involved in the process. So if you think about this system, it's clear the commission, the nominating commission, is the gatekeeper to the Kansas Supreme Court, meaning you can't get on the Kansas Supreme Court unless you become one of the three that the commission chooses. Doesn't matter how much popularity you have with the voters or the governor or the legislature or whoever. If you can't get past the commission to be one of the three, you can't be a justice. And whoever does become one of those three, one of them will definitely be the justice because the governor has to pick one of those three. So we really see the importance of the commission as the gatekeeper. And to kind of make that fun, but also with, I think, a really deep wisdom, I'm going to cite a great student of politics from my home state of New York, Boss Tweed, the Tammany Hall political machine. What Boss Tweed said, I don't care who does the electing, so long as I do the nominating. So Boss Tweed, looking at the Kansas Supreme Court Nominating Commission, would see the power there, right? Boss Tweed would say, okay, the governor gets to elect among those 3 finalists, but I don't care who the governor is. I care who does the nominating. So that makes us really interested in this commission. How is this commission selected? Who picks the pickers? And that's where Kansas is more extreme than any of the other 49 states. Kansas does something that none of the other 49 states do, although a few states are close, which is Kansas has a nominating commission of 9 people, 5 of whom, the blue over here on the right, are selected by about 10,000 people, and the other 4 are selected by the governor, who of course can be elected by all the people in the state, all the citizens in the state. So you can guess who these 10,000 people are. It's people licensed to practice law in the state of Kansas that we use as a shorthand, the bar, the Kansas bar. So this is the basic system of how the commission is selected. The governor appoints 4 of the 9, and the bar selects the other 5 of the 9. And Kansas, the only state I mentioned that gives the bar majority control in selecting the Supreme Court nominating commission. But several states are close. So this would be like going to the eye doctor. Now, if you can read, I'm going to ask, this will be testy if you need glasses. Can you actually read these states? You got good eyes. Okay, so you see I've got yellow for Kansas highlighted there. This is bar control of the state Supreme Court selection process, where Kansas has the most bar control. And then Missouri and a bunch of other states are close in that they almost give the bar as much control over the nominating commission. And then I'll go to the other extreme before I do the middle. The other extreme is states that have contestable elections, the Jacksonian democracy system for their state Supreme Courts. And you see a divide between partisan elections and nonpartisan elections. So several states have partisan elections for their Supreme Courts, and a bigger number of states have nonpartisan elections for their state Supreme Courts, although some of those nonpartisan elections are effectively partisan elections in the sense that there's 2 teams that organize and they put their candidate on the ballot and everybody knows which candidate is on which team. And then a bunch of states have what I call the federal model, or the U.S. Constitution's model of the governor's nominee is confirmed by an elected body, typically the legislature. There's still 2 states that have the legislature select the state Supreme Court. And then there's a few states, 3, that have that nominating commission system, but the bar doesn't get to pick members of the nominating commission. You know, as you could have a nominating commission where the members are selected by the governor, the leader of the legislature, the attorney general, the state's chief justice. There's a bunch of different people that different states use to select some members of a nominating commission. But some states also have 3 steps, and some of them are in this category here, meaning there's a nominating commission that takes applications and winnows down to finalists, and then the governor has to pick one of the finalists, but then there's Senate confirmation. And if you think about that, it means if the Senate votes no, then the commission has to go back to the drawing board and come up with new candidates. So having that third step really makes a difference in the power of the commission compared to the Kansas system, where the commission can dictate to the governor and everybody else, it must be one of these three finalists we selected. So you can tell, I think, that the criticism of the Kansas system and the other states that allow the bar to play a big role is that it's undemocratic. And so when the bar is defending its powers under the system in Kansas and similar states, the common question they ask is, why should judges be selected democratically? We don't select our doctors and plumbers by elections. Why should we select our judges by elections or some other democratic process? And it forces us to answer the question, how are judges different from plumbers? There is something similar about judges and plumbers, which is, okay, I wasn't going to make a dirty, kind of gross, it's lunchtime, but the similarity is there is some professional expertise to both jobs, right? Like if I tried to be a plumber, right, I could only do the bare, basic, simplest things. I don't have the expertise of somebody who's been doing it well, they were trained for it. Same with being a judge, there's professional expertise to that job. But there's a difference too, which is that judges sometimes make law. Plumbers and doctors and most occupations, we're not lawmakers. But judges sometimes are like members of legislatures and other bodies that make law. And when I speak to conservative groups, sometimes people are horrified by this idea. Judges making law, that's activist judges, that's bad. But in fact, it's routine and inevitable because statutes, what legislatures pass, inevitably have vague language or ambiguous language where reasonable people can disagree about how best to interpret that vague or ambiguous language. And sometimes legislatures do what I call punting, which is there's a hard issue they don't want to resolve, so they purposefully use vague language to punt it to the judiciary, let you guys interpret it as you want. So statutory interpretation, what judges have to do to resolve cases, inevitably involves some discretion for the judge. Hey, I've got vague or ambiguous language from the legislature. How am I going to interpret this and apply it to the case I have before me? And in doing so, judges make law. They make a policy decision to interpret it one way or the other way. And it happens. It's not every case, but it happens. Even more routine judicial lawmaking is the common law. Common law, going back centuries to England, is judges deciding cases the way previous judges decided similar cases. There is no legislation. There is no statute. Courts are just building on precedents from earlier cases. That's a very traditional form of law, and everybody agrees judges make it. So judges making law in statutory interpretation and common law cases, that's accepted by every lawyer I've ever met, including a famous critic of judicial lawmaking, Justice Scalia, who accepted that, yes, judges make the common law. That's how our system has worked for centuries back to England. Uncontroversial. So judicial lawmaking is routine. It's long established. But judges are human. So when judges make law, Liberal judges tend to reach liberal outcomes, and conservative judges tend to reach conservative outcomes. Not in every case, perhaps not even in many cases, but in enough cases to make a difference. Subconsciously or consciously, there's lots of data, stacks and stacks of books and academic papers demonstrating that it matters who the judges are, what's their ideology, how do they see the world. These are quotes from Vanderbilt law professor Brian Fitzpatrick, who's another person just very deeply involved in these issues as a scholar. So judges' ideologies influence the content of the law, how judges decide statutory and common law cases, and judges' ideologies are especially important in constitutional cases. Constitutions also have vague and ambiguous language where judges have to interpret, and reasonable people can disagree about what's the best interpretation of some constitutional language. But judges' constitutional interpretations have special, especially heavy weight, because legislatures can't overturn judges' constitutional interpretations. If judges interpret a statute the way the legislature doesn't like, the legislature can just pass a new statute to make more clear what the law is, and that overrides the judges. But when it's constitutional interpretation, overriding the judges takes a constitutional amendment, which is supermajority voters. That's much harder to do. So judges' ideology is especially important in constitutional cases. And the importance of judicial ideology is why the topic I'm here to talk about, judicial selection, matters so much. So I've got on the screen the US Supreme Court, the last 4 justices, what were their confirmation votes in the Senate, and you can see how close to 50-50 these votes were, and that's because of ideology. It's because of the importance of judges' world views. And it's not just the US Supreme Court or other federal courts where ideology matters in judicial selection. I've got recent examples from the highest courts of New York and Wisconsin. New York, a few months ago, had a Senate confirmation vote for the governor's nominee for the state's highest court, and the governor's nominee lost the vote, was defeated, and on ideological grounds. Even though the governor's a Democrat and the majority of the state Senate is Democrat, the objections from the state senators were from the progressive side, the left side, on issues ranging from abortion to labor unions to criminal cases. So it's an example of, at the state level, Senate confirmation vote ideology matters in the same way in federal courts. It matters. And then Wisconsin, you may have seen, had an election a couple months ago where it was a very clear, hard-fought choice between the more progressive candidate and the more conservative candidate, where the more progressive candidate won. And it flipped control of the Wisconsin State Supreme Court from 4-3 one way to 4-3 the other way. And everybody knew that's what's happening here. This is ideology in judicial selection making a difference. And it had national importance because Wisconsin is a swing state. So who controls Wisconsin law, including election law? Particularly important nationally. So I talked about ideology in judicial selection in examples of 2 of the 3 systems. I talked about Senate confirmation systems, and I talked about elections like Wisconsin. But what about in the 3rd system, the Missouri plan merit selection system like Kansas has? How does ideology impact judicial selection in our state's system? And if you think about it, who has the power to make their ideology impact the state Supreme Court. In the contestable election system, the power is with the voters, direct democracy. In the Senate confirmation system, the power is with the governor and the Senate, indirect democracy. And in the Missouri plan system, the power is with the governor and the bar, because those are the only two groups that play a role in selecting the nominating commission and then in choosing among the three finalists from the nominating commission. So the bar has power in our system. And in the contemporary United States, lawyers tend to be relatively progressive. And in nearly every state, more progressive than their state's voters and elected officials. As judges are nearly always lawyers, previous scholarship, this is me quoting those scholars I mentioned earlier, unsurprisingly finds that judges tend to be more progressive than their state's voters and elected officials. And then here's the terminology. I mentioned that Vanderbilt professor. Judges tending to be more progressive than their state's voters and elected officials, we're going to call leftward judicial skew. The judges are skewed to the left compared to the voters and elected officials. That's true in almost every state. But it's especially true in Missouri plan states. It's especially true in states that give the bar power in judicial selection. So this is me using academic language here. These findings support the straightforward hypothesis. That's how academics refer to common sense, what you would just think, right? That a judicial selection process empowering a relatively progressive group, the bar, tends toward more progressive judges, while judicial selection by the voters or by the voters' elected representatives tends towards judges more ideologically compatible with the voters. That, I think, is the uncontroversial reading of the data, just the facts of what's been happening. And what it leads to is a pattern in the Missouri plan states, the states that empower the bar in Supreme Court selection, which is the Supreme Court issues decisions, typically in those constitutional, ambiguous, vague areas of judicial lawmaking. The state Supreme Court issues decisions that are controversial with the voters and elected officials in the state, because the judicial decision is more to the left, more progressive than the center of gravity, the political center of gravity in the state. And then that prompts conservatives to oppose those justices winning retention elections. Or it prompts conservatives to change the method of judicial selection, or try to change the method of judicial selection. And then that leads progressive groups and bar groups to charge conservatives with trying to politicize the courts. If that pattern seems at all familiar in Kansas, Kansas is not alone. The same thing happens in the other states that give the bar power in the initial selection of state Supreme Court. So my own view, as you probably gathered, is stated well by a former dean of the Duke University Law School, which is no method of judicial selection is perfect. Broken timber, we're fallen, we're human. But the best of the various unsatisfactory ways of selecting high court judges is probably that prescribed by the Constitution of the United States, meaning the other two branches of government. Governor nominates, and then Senate or legislature votes to confirm. Why do I like that system? Because judges do make law, and lawmakers should be selected democratically. That's just basic first principle of one person, one vote in selecting lawmakers. But judges are different from other lawmakers, because judges are making law in the context of a particular case. There's parties litigating each other over some dispute. And in that context, we want rule of law. We want like cases decided alike. We don't want judges discriminating on the basis of this person's young or old, black or white, male or female, whatever. We want like cases treated alike. And particularly if there's a party who's controversial and unpopular, if a judge has to think about going to the ballot after ruling in favor of an unpopular or controversial party, then judge kind of looking over the shoulder, uh-oh, if I rule that way. So beauty of the federal system, the US Constitution, is that it doesn't have that. It has life tenure. It has a very long time for judges on the court. So they don't have to be looking over their shoulder after they're on the court, but there's democracy, indirect democracy at the front end of putting them on the court, those Senate confirmation votes. That's the basic case for having judges not by direct elections, contestable democracy, but by the indirect democracy of the federal model. And I just made that case that's now up on this screen, but I've got a little more detail here, which is Senate confirmation votes are public. Senators have to go on the record, yay or nay. I think that's good. I think that's accountability to the voters, and it's openness, it's sunshine in government, as opposed to some nominating commissions do not work that way. Some nominating commissions are secretive, where it's hard to figure out, journalists and others, who voted for who. Also, I mentioned life tenure. If I had to sort of criticize the framers of the US Constitution, who I normally defend, if somebody said, you gotta criticize them, what would you criticize? Life tenure. That worked better when people died younger. Now I use the academic phrase long non-renewable term, meaning Supreme Court justices, imagine if they all had 18-year terms. And when your 18 years are up, you're done being a judge. You go off to your grandchildren, you go fishing, you write a book, whatever it is, but you're not a judge anymore, right? That would be the one change if I could, be king for a day and change. So I'm getting near the end, and again, I'm going to look for your comments and questions, but what I want to do here is a table that just kind of reviews the big picture and plugs Kansas into it. I mentioned at the beginning, I started with that distinction between selection, what first puts a judge on the court, and retention, what decides if the judge stays on the court. And so I've got selection up at the top in red, and then I've got retention over on the left side, I'll say y-axis for some of you, in blue here. And so what you see is you could have contestable elections, candidates running against each other, to initially select, is this judge going to get on the court? And then after a term is over, have a contestable election to decide, is this judge going to stay on the court? And that's how trial court, district court judges are selected in Sedgwick County and Wyandotte County. Contestable elections, so that sort of Jacksonian direct democracy system that several states use for their high courts, their Supreme Courts. These very populous counties have for trial court, the lower court. And then the Senate confirmation system with, going down to the bottom, the long non-renewable term, meaning you can't kick the judge off the court until the term ends with life tenure. So that's U.S. Constitution. But that system of Senate confirmation doesn't have to be combined with life tenure. It can be combined, as we have for our Kansas Court of Appeals, with retention election. And retention election, I mentioned earlier, is typically associated with Missouri Plan, the merit selection bar power system. So the way our Kansas Supreme Court has been selected, has been the focus of my discussion just now. Missouri Plan, initial selection by that nominating commission where the bar plays a big role, and then retention election when the judge's term is up. No Kansas Supreme Court justice has ever lost a retention election, and nationwide it's 99% of incumbents win retention elections because, as politically active people know, it's easier to win an election when you don't have an opponent, and that's how retention elections work. And I've got here Douglas, Johnson, Shawnee as counties in Kansas that use that same system for our district courts, our trial courts. So you can see a variety of different systems and some of the courts in Kansas where it's all used. And I think that's where I wrap up and look forward to your comments and questions. Thank you.
Dr. Ware, thank you so much for being here. In conservative Kansas, how do we change our Supreme Court selection process?
That's the question. So I mentioned, and John kindly mentioned, how long I've been at this issue. About 10 years ago now, Kansas did change. The Kansas Court of Appeals, our second highest court in the state, from the Missouri Plan system. Kansas Court of Appeals used to be over here in the Missouri Plan system with Kansas Supreme Court. And legislature changed that to the Senate confirmation system. But that was because the Kansas Court of Appeals is not in the Kansas Constitution. It's created by statute, which means the legislature only needs a bare majority to change how it's selected, which is what happened. Whereas similar efforts to change the Kansas Supreme Court, that would take 2/3 of each house of the legislature, and the effort to make that change fell a little short of getting the 2/3. So the answer really is constitutional amendment takes a supermajority of the legislature. That's where the issue has been for over a decade now.
So thanks for being here, Professor. Two questions really. One is, what do all the other counties do that don't do Johnson, Benjamin, Shawnee, and all that?
Yeah, I didn't have a whole lot of space. Kansas has 105 counties, and I think I have the 5 most populous on the screen. So the other 100, they're split between the two systems that you see the populous counties split here. And some of the less populous counties combine to be a judicial district.
The other question is, has Kansas always had this current selection process, or did it used to be different?
Yeah, it used to be different. So Kansas, one of the states that had elected Supreme Court. In that history lesson about Jacksonian democracy, central time zone, Kansas was one of those states that came into the Union with contestable elections. And then the change to Missouri Plan in the 1950s is a story. Anybody ever heard of the triple play? The triple play? So great, you can tell us the story. You remember what happened? So basically, governor lost election And Lieutenant Governor filled in just for a very brief time because the governor resigned, so the lieutenant governor could appoint the governor to fill a vacancy on the state Supreme Court. And that seemed, as the kids say now, suspect, suspicious, fishy. So there's a lesson, I think, though, which is that suspicious insider deal was to fill a vacancy, meaning had no Supreme Court justice left the position midterm, the question of who the new justice would be would have been selected by the voters in an election, which is what made it a triple play. You needed not just the governor and the lieutenant governor, you needed a Supreme Court justice to resign midterm. And if you'll indulge me one quick story, this is actually what I'm working on in my next big article, which is the sort of strategic retirements that justices in many states do to create a vacancy and have that impact on how the successor justice is selected. There's some really interesting stories I hope to be able to tell in the future. Did I answer your questions?
You did.
Thank you.
Okay, next question, appearance.
You have indicated that the majority of the nominating committee is made up selected by 10,000 voters. Does this not violate the constitutional principle of one person, one vote, and make the system unconstitutional? The second question, may I ask two questions at once? The matter of federal judges and justices could, and their lifetime terms doing good behavior, could this not be addressed if we have a convention of the states as some proposed?
I can definitely answer the first question. I might need a clarification on the second one. So the first question was, this system is a really good question. Doesn't this state selection system violate the U.S. Constitution, which has in the 14th Amendment equal protection clause? And courts have said no, because the principle of one person, one vote, that is constitutionally required by the Equal Protection Clause when it comes to legislatures, but not for judges. So it's not as though courts are saying this system complies with one person, one vote. They're saying, states, you don't have to comply with one person, one vote when it comes to selecting judges. Now, I will say U.S. Supreme Court hasn't taken that issue yet. So maybe they will at some point. Then your other point was convention of the states. And if I heard correctly, but fill me in if I didn't, your point was that what could be changed?
The lifetime appointment
Yes.
for judges and justices, since one of the matters to be considered for that convention of states is term limitations, could that not apply to federal judges?
Yeah, that's right. Constitutional amendment can be accomplished in the way it's always been accomplished, but also in that way, and it would take a constitutional amendment to end life tenure of federal judges.
Go ahead, Doctor.
So I have got two questions. One question is, do the judges retire? If so, what age? As you know, doctors and plumbers don't retire. How about the judges?
That's a really good question, and it goes to that strategic retirement point I was just talking about, which is in Kansas, like nearly all states, we have mandatory retirement ages for Supreme Court justices. And legislature raised it from 70 to 75 several years ago. Here's the key, though, which is in Kansas, which I think of as normal state in this regard, as the states I've lived in, New York, Alabama, Kansas, they all do it this way, which is when you hit the mandatory retirement age, you don't get kicked out of your job that day on your birthday. You get to finish out the term of office that you're in, you just can't seek a new term of office. Whereas what some states do, and this is part of the suspicious insider stuff I was talking about earlier, some states kick the judge out, not quite on the birthday, but very close, which creates those vacancies, creates those midterm interim vacancies that get filled by the governor, sometimes in a Missouri plan kind of process that empowers the bar in some states, as opposed to if you let the 75-year-old judge finish that last term, then you have the normal selection process for a new full term, which in some of these states is election. So what's happening in some states, I'm not talking about Kansas now, what's happening in some states, Minnesota and Oregon, by the way, are the big examples of this, Georgia too, is you read the state constitution, you think there's elections for the state Supreme Court, but it's so common that justices leave the court midterm in those states, and then the governor fills the midterm vacancy, that actually most members of those courts are appointed rather than elected. You had a second question?
Yeah, that's another thing. I'm sure you heard about former President Trump. You know, he took some documents to his house in Mar-a-Lago in Florida. He was indicted, and if the case comes to you, how do you decide?
I would not want to be that judge. Fortunately, I'm not that judge. I'm sorry to say, I just don't know the law in that area. Yes, sir.
Yeah, okay, is the right to abortion in the Kansas Constitution?
So there's an example of a constitutional interpretation that fits the pattern I talked about of more conservative judges tending to interpret in a more conservative direction and more progressive judges tending to interpret in a more progressive direction. So abortion, definitely an example that we've seen in Kansas. School funding, another example that we've seen in Kansas. In Iowa, back before the U.S. Supreme Court ruled on same-sex marriage, Iowa had this issue on same-sex marriage. Some states, going back to California, have had it on criminal law issues. So a variety of constitutional issues, abortion included, are examples that we see in several states of judges' constitutional interpretations correlating with what ideology the judges have. Yes, sir.
Quick, simple question. Why have we on the right picked up calling the left progressive, which sounds neutral?
Okay, I'm glad you asked that because it lets me put my own cards on the table, which is I grew up in a world where what I now call progressives were called liberals. And then I learned that I'm a liberal in the classical sense that the framers of the U.S. Constitution and John Locke and Adam Smith and John Stuart Mill are liberal. So I'm trying to take the word liberal back from the left for classical liberals. And I am not too influential, but I do it when I give talks like this. And people on the left have adopted the word progressive now, so they're kind of helping me take the word liberal back for what we kind of had to invent the word libertarian because liberal had been taken from us. That's my personal view, unrelated to judicial selection. John.
I really like this. You know, you've given us an idea of how you think on these, and I think we need to accept your wisdom. And would you be willing to help our legislature with language on Senate or House concurrent resolution that would amend our Constitution?
Yes, but that's already been done a few times. Legislature has had HCR, SCR, and as I mentioned, one almost got the 2/3. So good language has been out there. It's the winning the votes part that's been the obstacle.
We got time for one more question.
I'll ask it. An example of the most egregious or blatant partisan decision that you've seen.
Oh gosh, I don't know if I have a good example of most blatant partisan
We think
decision.
about the abortion or even school funding, but
Yeah, we could debate that till the cows come home. It's a good question to sort of point the finger. But what I will say is that when people who oppose me on this articulate why, they say, well, you know, conservatives are just trying to take over the third branch of government. They've already got usual control of the first two branches of government. And obviously governors flip between parties, and obviously Kansas has had moderate Republican governors in the not too distant past. But there is something I've found valuable to be able to tell people, I'm arguing from principle, not to achieve my preferred policy outcomes. I believe in the principle of one person, one vote, not just for Kansas, but for the other 49 states too. I go to Missouri and other states and I make some similar points, and I believe in indirect democracy rather than direct democracy for selecting judges. In other words, I'm making a point from principle. So you shouldn't say, oh, I don't want conservatives to get control, so therefore I have to abandon my principle of one person, one vote. There's a lot of Democrats, progressives, who are really on a high horse about democracy. And it's helpful to be able to say, hey, what do you think about this? And they have to say, oh yeah, this is undemocratic. This is privileging our side, the progressive bar. So that's my suggestion. Thank you all very much. I really appreciate it. Thank you.